misrepresentation, failure to disclose. We had to deal with those serious allegations when it comes to applying for this M400 application for naturalization. Finally, we won a year later. In this video, I'll talk about the timeline and what we had to do. Remember that we had to work closely with the Office of the Attorney General in Ohio. Say hi to my friends in Ohio, because we really had to collaborate to come up with something like a deal in order to defend our client before USCIS. My name is Bijoux, Ngwanda, I'm an immigration lawyer based here in DC. I do work with individuals across the country and around the world because we're dealing with complex U.S. immigration laws cases. If you're new to my channel, please go ahead and subscribe. If you're not new, welcome back. Thank you for subscribing, and please do not forget to hit the notification bell so you don't miss out on anything. If you enjoy the content, you go ahead and share, like. Don't forget to comment below. Also follow me on Instagram because we are talking about employment-based immigration, the business side of immigration, and we're giving out tips, a lot of them. Okay, you can also join us on our private Facebook group because you can privately ask your question there. We do answer questions live at least twice a month. We try our best. Let's get right into the topic. Client applied on January 12, 2022 for the application for naturalization because she wanted to become a U.S. citizen. 5 days prior to the interview was scheduled on July 5th, 2022, pretty much 6 months later, right? 5 days prior to the interview, the client came to me and said that she had serious problems, failure to disclose. I was surprised, just like you're surprised now. What are those problems? She said that she had registered to vote in a federal election. Big no. You cannot do that. You cannot register to vote in a federal election. You cannot falsely claim your citizenship. And as a matter of fact, you cannot just vote in an election when you are not U.S. citizen, especially not in a federal election. So when she came to me, I was really upset, but I had to deal with her and I had to deal with the charges, right? Like how I charge her, the pricing and all that. But anyway, we had to really go deep into the problem. The first thing we did is to admit to the facts. Disclose the facts on the day of the interview. Remember, she came to me 5 days prior to the interview, and because the interview was scheduled on July 5th, 2022, I was like, okay, what are we gonna do? Today is July 1st, but when we go to the interview, we are going to disclose those facts. The first thing we did is amend the application on the day of the interview. You do not wait until the day of the interview to amend. However, you can still amend the your application on the day of the interview. In our case, we had to just wait for the interview because it was just like 4 days apart, right? From the day she actually told me to the date of the interview, just 4 days apart. We're like, you know what? We're just gonna wait until we actually go there. Then, well, of course, as you know it, the officer did not give us a response. She passed the civic test, okay? But the officer cannot give us a response based on those new facts. They have to investigate. So we had to wait. On August 11, we received a request for evidence. That's when we had to defend ourselves. So we had to go deep, dig. That's when we reach out to the Office of the Attorney General in Ohio. Again, good people in Ohio. Say hi to my friends in Ohio. Remember that we are defense lawyers, right? We defend our clients in court before USCIS, before CBP, before ICE, or in federal court or at the U.S. Embassy. So that's our job. We're on the defense side, but we still have to collaborate with the government when something happens. So So that's why we had to reach out to find out exactly what happened, okay? Because remember, on this case, the FBI had to investigate. This is a federal matter. Register to vote when you're not a U.S. citizen in a federal election, it's a crime, right? So the FBI, had to investigate on this matter, and we had to actually just convince USCIS that our client lacked the criminal intent to actually vote in a federal election. Why? Because she did not, thank God, on her registration, a voter registration card, she did not falsely claim U.S. citizenship, and she did not actually vote. However, she did cancel it later. She canceled that registration card 4 years later. She came to the U.S., she registered to vote, mistakenly, I believe, I suppose, but she did cancel 4 years later, like almost couple months prior to applying for U.S. citizenship. Not to mention, she failed to disclose those facts, right? You see how it looks like, but we had to just defend because it's our client. We defend within the limits of the law, of course, okay? We don't do anything else. We just have to defend within the limits of the law. So the Attorney General, they really, thank God, again, a big thank to them. They actually exercise prosecutorial discretion. Remember, we've talked about prosecutorial discretion before, the power that the government has to drop a case, to prosecute or not to prosecute. And in our case, we had good good luck on our side too, right? But they will look at the totality of circumstances, right? They find out too that the client lacked criminal intent because she did not actually vote. She did not falsely claim U.S. citizenship. And by the time she actually registered to vote, she just came to the U.S. She really lacked the knowledge of what was going on. So, but the fact that she actually canceled late was debatable. Like, well, if you didn't know, but why just prior to apply for U.S. citizenship you come and cancel? So that was open to debate. But again, when we do our job, we're so good at that, right? We did our job. They did their investigation. We did our job. We convinced USCIS about the lack of intent. And on the other side, the Office of Attorney General also exercised prosecutorial discretion. So we took that prosecutorial discretion that they had exercised on behalf of our clients and the lack of intent as our argument, all those documentation, we had to convince USCIS that although she did register to vote, although she did cancel late, our client lacked criminal intent to commit this type of crime. And USCIS agreed with us, and yesterday on December 15, we got an approval. So now she's online to wait to take the oath. She's gonna receive the oath ceremony notice anytime soon, and she is going to take the oath of office. What is the moral of the story? You cannot withhold facts. You cannot fail to disclose the facts. You cannot misrepresent facts because it's going to cost you an immigration benefit. She was lucky that the Attorney General decided to exercise prosecutorial discretion. But remember that the Attorney General could have charged her with attempt because the proof was there that she did register to vote and she canceled late. So the element of attempt was already there. Like, this person attempted to vote because why she did register. They could have charged her with that, but they decided based on the totality of the circumstances, they decided to just drop the case and to exercise prosecutorial discretion. That's their discretionary measure, okay? And on the other side, the USCIS too could have decided differently, but because our argument was so strong, on point, USCIS had to agree with us, okay? So we were able to deliver. So representation matter. If I haven't said it, sorry, if I know I've said it before, right? And I'm gonna say it again. Representation matter. If you have difficulty with your immigration petition, don't take the risk to just do it on your own because you have some notion of immigration. When it comes to legal argument, you need a qualifying attorney. If you do not have one, again, please contact me. We can try to see if we can help you. We do take a lot of pride in writing our argument. We do take a lot of pride in our performance. We do take a lot of pride in our counseling, and we do take a lot of pride in our integrity in telling you whether or not we think you have a chance at winning. Of course, we do not guarantee results because we cannot do that based on the law of professional responsibility code. We cannot do that. However, we can give you some hint, right? So that's why representation matter. And we have another case about TPS that's straightforward. However, we had to apply with a waiver. It took us 6 months from June 16 to December 15. Finally, we got a response. We had a request of evidence on this case as well, a TPS. Not sure why, but we did it. They just wanted a lot of documentation to prove nationality, even though we already provided some, but they wanted more. And we delivered. We gave them more documentation to show a proof of citizenship because the client is from Cameroon, okay? So, yes, two great news. This is great news for December. Again, we're reaching like almost the end of the year. What is your plan for next year for your immigration? We've been talking about the year ahead. What is your plan? If you do not have one, call us. You can come up with one if there is one, okay? So this is great news for us. Please share, comment. Let me know what you think in the in the comment section. Until next time, bye-bye.